So Zishan, please stand by. हो सकता है कि you might have to go after Aisha in the beginning.
Should we begin? We are on time actually. We have Zishan.
Awesome.
Zishan.
I'm sorry, the link wasn't working. In fact, I was trying to open.
Okay. It's fine. We're just beginning. We are also live on Facebook.
Zishan, looks like you just had breakfast.
Gee, you got it rightly.
Yeah, I can tell from your body language here. But good to see you.
Thank you, sir. Good to see you.
For those of you who can rename yourself, I would suggest if you are from Kinnaird, just try to add the NHLD at the beginning or end of your name. And if you're from Islamic, I would appreciate if you can add IIUI to the name there. That will help us identify.
I think we should start. Assalamu alaikum and a very good morning. I am Aisha Jawad, head of Nadira Hassan Law Department, Kinnaird College for Women, and I welcome you all for today's third and final session of the webinar series, Current Trends in ADR Spotlight on Mediation. This series of webinar is a collaborative effort of the Asia Foundation and Nadira Hassan Law Department. Today, our main focus is going to be on the different aspects related to mediation, its process, anatomy of mediation, what is important, when a mediation is in a process, and the other aspects attached to it. An eclectic line of speakers will be joining us today, and they will be talking about that how mediation has affected the current litigation system, and they'll be sharing information, and definitely, like always, they are always the source of inspiration. Without further delay, I would like to invite Mr. Zishan Ali. Zishan is a trained rule of law advisor and works for Asia Foundation as a team leader, Alternative Dispute Resolution Project. Zishan is a JAMS accredited mediator. In addition to his role with the foundation, he serves as an advisor to the ADR committee of the Lahore High Court Bar Association. He is also a member of official ADR committee of Lahore High Court. Zishan is an advocate of High Court and member of Islamabad District and High Court Bar Association. Thank you, Zishan, for joining us, and please tell us about the project.
Thank you, Aisha, for this generous introduction. I owe you a word of gratitude. So I would like to share a project presentation, just to give a snapshot of how the work is and how the project activities are. So please let me know when you get to see my screen. Can you see it now?
Gee, we can see it.
All right. So thank you. Assalamu alaikum, everyone, and very good morning. My name is Zishan, and I work with the Asia Foundation. This project started in September 2016, and it's titled as Mainstreaming Alternative Dispute Resolution for Equitable Access to Justice. So the broad outline of the project is to facilitate people who cannot otherwise pay for the justice sector services, or who would otherwise remain deprived of accessing the justice sector services. So therefore, we try to mainstream and integrate the ADR mechanisms within the legal as well as the judicial fraternity to extend pro bono legal assistance and speedy justice to people who deserve it the most and who cannot access it because of the lack of resources. So I will take you to project goal. So the project goal is to mainstream alternative dispute resolution mechanism in the judicial system of Pakistan and facilitate broad-based access to equitable justice, in particular for marginalized segments of society, such as women and the poor, as I pointed out. So the three key activities we have is the capacity building of judiciary and sensitization of the Bar Association, so that both work side by side to complement each other. One of the major and fundamental component of the capacity building and to mainstream ADR is to work with academia. So since the very inception of the project team has been working with law schools. So we started with Kinnaird, and then subsequently we extended the project to International Islamic University. And it's been a flagship program with academia. It's been such a pleasure working with Kinnaird, with Aisha Jawad. So we have the privilege of having Professor Ahmed Salman here. He has been very instrumental in generating support from day one when he was a voluntary member of the advisory board, the core group for this project we have. And he worked with Honorable Justice Tasadduk Jalani to develop a course curriculum which has been adopted by the law schools now as a full semester course by Kinnaird as well as Islamic University. Now we are taking more law schools on board, and some of them are imparting training based on this course curriculum as a 1-month training course. But the idea is to have them all adopt the course as a full semester course, so that it's sustainable. Once we pull out the resources, the course stays there, and the students continue to benefit from the course. And the third fundamental and very essential area is communication and outreach, which means to tell people to increase their level of awareness and tell them about the existing ADR structures and mechanisms, so that they make recourse to the ADR mechanisms, they use the processes, and then that's how we get to know about the utility of this very effective remedy that people have. So talking more about the capacity building of the judiciary, so we conducted some master training program for judges from Punjab as well as judges from Sindh. And the idea was to have them trained as master trainers so that they can come back to their respective judicial academies and they can impart the training sessions to their fellow colleagues, also train their colleagues on job. Furthermore, we held some, some other training sessions at the Punjab Judicial Academy, for instance, understanding mediation. So this was also led by Aisha and Professor Ahmed Salman. It was a very, very fruitful activity in terms of, engaging with people and generating their interest, enhancing their interest. So this was followed by a series of training sessions on referral mechanisms. So the then Chief Justice, Honorable Justice Anwarul Haq, who participated in the last session, we had a detailed discussion with His Lordship, and we then, agreed to sensitize the working judges, not the judges who were assigned as mediators and they were trained as mediators, working with the mediation center, but those who were running their regular courts. So we conducted an intense training program for those judges to start referring the cases to mediation center, which produced tremendous results in Punjab. So similarly, we have been engaging with the bar associations in Sindh also. So we got their judges, 8 of their judges trained as master trainers. They came back and they started going to the bar associations in the interiors of Sindh, and they started engaging with the lawyers. The response we have so far is very encouraging. So academic course, I already talked about it. It's adopted by Kinnaird and International Islamic University. Then we have the communication and outreach strategy. So we also developed some communication material. In the future, we'll be developing more. We'll be working with some production companies to reach out to public through TV, through mini-series and commercials and radio programs. But the material that we have right now is some flyers and posters that we sent out to the Honorable Lahore High Court, and we're sending it out to the Sindh High Court and Sindh Judicial Academy to spread the word at national level. We have the social media campaign ongoing. So we have a Facebook page, we have a Twitter account where we post all the project updates. Our team writes blogs, not only the team, but we also speak with the institutional partners. For example, Kinnaird College, and we have Law and Justice Commission of Pakistan. We have other law schools. So we encourage people from the partner institutions to write blogs, and then we can share. So at the same time, we have this community engagement component going on. I would like to share the flyers and posters with you. So here is some material that we already developed, and we sent it to the Honorable Lahore High Court. So it explains the process in a very simple and easy language. Also explains the efficacy of this ADR mechanism in the court annex mediation model in Punjab. So here are some more examples. So so this is something that we try to share with people, as an attempt to let them know about the existing structures and, motivate them or encourage them to use these processes. So that was it from my side, but if anyone has any specific question, I am very happy to respond.
Thank you so much, Ishan. It was really informative, and thank you for sharing that what Asia Foundation has been doing in materializing this project and the effort your whole team is putting into, have mediation in a spotlight and in the mainstream. Thank you very much. We are taking questions, so there's a chat box. Isme questions are in, so the moment jaise questions aayenge, we'll be asking you, we'll be requesting you to, cater them.
Sure.
Without further delay, just move on. I would like to, it's always a great pleasure to introduce Mr. Ahmed Salman. Ahmed Salman has over 26 years of experience in the field of learning and development and is an international subject matter expert in alternative dispute resolution. He has trained in the area at Harvard Kennedy School's program on negotiation, Queen's University Smith School of Business, Canada, and at Essex Business School, France, under some of the great influential names in the field. He is a member of the ADR Institute of Canada and the International Association of Conflict Management. Ahmed has been teaching and training in ADR for more than 15 years and has designed, developed, and delivered several modular programs in academia and industry in North America, Europe, Middle East, and Pakistan. As a practicing ADR professional, Salman is involved with the Asia Foundation's mainstreaming alternative dispute resolution for equitable access to justice, especially for marginalized people project, as an advisory board member and ADR curriculum consultant. He's currently affiliated with the University of Victoria, Father Dickinson University of Vancouver, British Columbia Public Service Agency, and is a board member of NAS Business School in Pakistan. Thank you so much, Ahmed Salman, for joining us. And seriously, आपका introduction कराते हुए मैं थोड़ा सा थक भी जाती हूँ. Mashallah, you have achieved so much, and we are honored to have you on board. Thank you so much.
Thank you, Aisha. Always a pleasure. And you know, when you doing this introduction, I wish I had sent you a shorter one because it seems like किसी और बंदे की बात हो रही. Allah has been very kind. You know, it's our third session today, and you know, when we were doing our first one, we had different goals at the time which we set for ourselves, but the distance we have covered in terms of the content and the expertise of the people that has been shared, and you know, we've been really fortunate to have some amazing panel members. I would like to acknowledge the traditional territories of the Esquimalt and the Wasanich First Nations here, where I live, work, and play in Canada. And this is something that kind of is second nature to us now to acknowledge where we are. Of course, all praise to Allah. We can't take away from that, and we should always be mindful of this. I also would like to acknowledge the support of Asia Foundation, especially Zishan and his team. They're phenomenal people. Your support, Aisha, without which these programs would not have been possible. We do have Usama here, and we did see him open up his camera. So thank you very much, Usama, for your support and for your presence. And we really look forward to hearing from you. I have just been informed that Aisha has invited a couple of students to share their experiences to kick off our program today. And we should very soon be hearing from them. Back to you, Aisha.
Thank you so much. As Zishan has mentioned, you know, their commitment towards mainstreaming mediation in ways of community engagement and developing of the curriculum at the undergrad and the postgrad level of law. So I just thought that we will be sharing as a partner law school our own experience of introducing mediation as a major course at an undergrad level. Because like everyone, we had apprehensions at the very start at how we are going to conduct this course and how the practical, you know, implications will be working. But with the passage of time, you know, I can say that this was one of the very successful courses we have designed, and you know, Ahmed Salman Sahab has designed it, and we have implemented it. So I have invited two students who will be sharing their experience. One of our students has graduated. She's just recently graduated, and one is in final year. So we can have, you know, we can just speak to them, and they can share their experience from a student perspective and from a very, very young lawyer perspective. Do we have Atika and Ms. Habiba over here? If you, okay, thank you. Sir, if you can just stop sharing the screen so we can.
I will just do that.
Yeah. Thank you, thank you. So we have Habiba over here. Do we have Atika?
Yes, ma'am.
Oh, thank you, Atika. Thank you, Habiba, for joining us. Habiba is in final year student, and Atika has just graduated. And Atika has also done some research on ADR. So I would like to just, you know, ask you a question. Well, I think Amitsa will be the right person to ask you a question because I've been teaching you ADR. But I just really want to know that Atika se particularly मैं question पूछूंगी. As now you are in a field, do you actually feel the difference that this course has taught you any professional skills which are beneficial for you in your practical life?
Yes, definitely, ma'am. ADR is now an emerging trend in the modern days, and it's extremely important for students to have it as a part of their compulsory modules. And I'm lucky that I've had the opportunity to study ADR, which was a very well scheduled and very well taught course. And you've been teaching us. And since the courts are too burdened up with the cases, it wouldn't be incorrect to say that if a few of this burden is shifted to the ADR courts and alternative dispute resolution mechanisms are adopted, our judicial system would definitely be improved. Hence, in order to bring a positive change in our judicial system, it's necessary that ADR mechanisms be adopted and students be taught this course in their universities so that they are aware of the technicalities and complications that may come along.
Yes, I think you're right. Yeah, we really need to work on practical aspect of these courses. Emitsa, would you like to?
Yeah, I do have a question, and I want to hear from Habiba as well. First, before I do ask this question, so I can actually go ahead. So, Habiba, what has your experience been like, and what do you think? What kind of competencies and skills did you learn from those courses that you are now able to kind of look back and say, this is something that's going to help me?
Sir, I had a very positive impact from these courses, mainly because when I started interning in different law firms, we saw a shift and a trend change from formal litigation towards lawyers more adopting mediation and opting for arbitration. In these scenarios, I felt more prepared and I felt more knowledgeable in the sense that I was able to help them out in these scenarios professionally, and moreover, on a much more client delayed basis, I would also be able to be more helpful towards them, be more negotiable towards them, and in that scenarios, it was really helpful.
Okay, awesome. So, now I don't know if you've attended our previous seminars or not. We were talking about a few attributes or skills that we kind of say that, even if you don't end up becoming a mediator, there are facilitation skills or interpersonal skills that you carry out of this program, or if you're exposed to a course like this. And also, I think one of the important competencies that comes out of this is emotional intelligence, where you are able to be more self-aware, self-regulate yourself, and showcase some empathy, and have more motivation towards resolving a dispute with the positive mindset. So what do you think? Have you, and from what I hear you've been saying, is you have been applying some of those concepts?
Yes, absolutely. Especially when it comes to being more facilitative and being more emotionally intelligent and aware of your client's needs. It was absolutely helpful there on that regard as well, in order to contribute, in order to help them out to get their relief and to achieve what they wanted. These skills were very important, and I believe that this course was absolutely successful in delaying and in conveying these messages or these skills towards us.
So I would basically throw this question to both of you now, and again, and either of you could choose to answer. If you think this course is to be taught again, and if you are attending that course, what would you want to be done differently? Is there something that you would say, what, if I had more of this or less of that? Do you have anything that you can comment on in this context?
In my opinion, since we had a much more theoretical and a bookish study of the courses, even though it paid off very quite well, but I guess an observation session would really be helpful, especially when it comes to mediation and negotiation, so that we can see straight on how these proceedings end on, kind of like a shadowing system. It would really help us how these proceedings go about.
I think that's very good feedback. Yeah.
Yes, I think a bit of a more practical aspect is needed.
And I really appreciate that, Atika, because I think that is what we have been talking at our end, also trying to sort of dissect what we've done before, learn our lessons out of that, and the next time we do this, of course, you can understand that when we launch a program, we have initial teething issues, and you are also learning along the way. And the way this has been done and the way it has evolved is organically turning into a very, very strong program. And this is what I've been talking to Aisha, and I'm sure the next batches will benefit a lot from this feedback.
Yes, yes, definitely. Zishan?
That's very right. So Aisha, I have a question for Atika, if I may.
Please,
So,
sure.
Atika, since you are into the practical life already, you're practicing law. So, are you going into are you applying ADR, and what are the categories of cases where you think it fits the most, where it works the best in your understanding?
So I have come across a few divorce cases where ADR should have been used, and we do not have proper mechanisms for it as of now. So if we do have some proper mediation law, that would be of a great help.
Right. So I think we have the laws already, but the implementation is somewhere in the pipeline. I hope we get to that point very soon, since each one of the stakeholders is already talking about the need, and it's critical, in fact, to implement those reforms. But also the procedure given in the Muslim Family Laws Ordinance, if you know that, the reconciliation attempts, and the three opportunities afforded by the court. It has an inbuilt mechanism, ADR mechanism. But yes, I think mediation should work the best there. Thank you for sharing that.
I think that's interesting input, Zishan. And today we will again benefit from Osama's presence to have a more pointed answer to this one when we reach out to Osama, or maybe we can have him chime in now. Assalamu alaikum, Osama.
Assalamualaikum. How are you, Salman Saab? Pleasure to be here again. Aisha, Zishan Saab.
Thank you for joining, Osama. And thank you for always taking time out.
No worries, no worries.
So Zishan asked a question, and perhaps Atika also mentioned, and she did say we wish we had mechanisms or whatever in place to address some of those cases. So maybe now would be a good cue for you to share
I think
your insights.
mechanisms are already in place now with the promulgation of the ADR Act 2019, and in continuation of that, we have ADR Rules 2020 as well, which clearly lays out all the criteria that is required and what kind of cases can be referred, which includes, as one of the students just mentioned, divorce cases as well. And I think that with the advent of these laws in the field, a lot of things will change eventually. But I think these are relatively very new laws, and I think that they'll require some time for their implementation as well. And along with the time, there needs to be training and sensitization of judges as well, because primarily they are obligated under these new laws to refer cases to arbitration, obviously with the consent of the parties. But the primary duty of taking these cases and referring these cases to mediation or other forms of ADR is on the judges. So until and unless judges play a more proactive role in this regard, I think that implementation will be sooner if judges play a more proactive role.
Thank you, Sama. It's really something that has to happen, of course. Yeah, Zishan.
Sorry, sir. So Osama, I have this question for you. It's a good law. It's a very good attempt, as we know. But do you think it aligns very well with the mandate of judiciary? Because the kind of structures they have there, the court annex mediation model, you train some of them also, and you talk to them. Do you think the law fits into the existing framework they have? I was just curious.
I think it fits perfectly. The law is made with utmost dedication, and the writers and the drafters of law, they've kept our legal structure in mind. But the problem, once again, is with the lawyers, that they don't advise their party, they don't advise their clients to take a more proactive role and take a more facilitative approach towards mediation and other forms of ADR, and to refer their cases to ADR. So the problem again lies because ADR, as I mentioned, is through consent of, it can only be achieved through consent of both the parties. So even if one party agrees and the other party does not agree with the referring the case to ADR, that won't happen because the judges require consent from both the parties. It's written down in the law. So I think we'll have to, it's a long journey. And I think that all of us should play a more proactive role, especially the bar councils and the judiciary, because the role of bar councils and the bar associations is also very important to basically tell the lawyers and basically train them to in the ADR process as well. So I think that judges and our superior judiciary, I think the role of superior judiciary like the high courts and the Supreme Court in this regard is important, because our district judiciary works under the framework of the high court, and then the overall supervisory role is with the Supreme Court. So until and unless they have a more empathetic approach towards ADR, the lower judiciary won't refer cases to ADR under the new law, even if it's fully implemented. So I think that there are three key players in this regard. One is the judiciary, the superior judiciary, then comes the lower judiciary, who actually has to refer cases to ADR, and then comes the lawyers and the bar association. So I think until and unless all three actors are on the same page, there will be difficulties in implementation.
Also, Osama, I mean, you're absolutely right. It's a very nice analysis of how different actors can contribute to promoting it. But I would like to share a very recent experience with you. So I was in Karachi last week, and we had this ongoing session on mediation with the senior civil judges there, the lower judiciary, as we say. I hope you are aware of the recent amendments in the Civil Procedure Code they
Yes.
have carried out.
Section 89A.
89A, and also they have added 89B, 89C. They have incorporated some very nice self-explanatory clauses, that will also explain the processes. And as an attempt to make the judge bound to analyze every case, and to see if it's a good fit for referral to ADR. I think it's a very good attempt also in a progressive legislation. It may not be perfect because it's just a first attempt, but at least it details the outline and the processes, for people to be able to understand and encourage them to apply it more. And then there is this ongoing training program for the judiciary to make them aware of this law. And at the same time, as you rightly pointed out, the lower judiciary and the Supreme Court then has to take some administrative action, because last time when the centers were set up, they exercised their powers under Section 122 of the CPC, which means the administrative powers of the High Court to make decisions. But at the same time, what we perhaps do not mainly stress on is the application of Section 35 of the Civil Procedure Code, which contemplates the damages and the cost of the litigation. So I think perhaps that can also help. It's in my humble view, in encouraging judges to start referring cases, and then introduce cost, award cost in the cases where people have initiated frivolous litigation. So something, but I wanted to highlight this law that they have in Sindh. I think it needs to be looked at. Maybe it's a good step towards.
I think Zishan, it's a pertinent discussion for our forthcoming sessions. I think we need to dig deeper into this and spend more time looking at it. And I think that's a very important discussion that we would benefit from. And I really appreciate you bringing this up at this time. Aisha. And Osama, I would throw in another question to you guys, and both of you have been educators of mediation in your respective associations as well. Aisha in the Nadira Hassan Law School, you have been associated as an educator, Osama, in one of the law schools in Lahore. So, and I think we would like to benefit a little bit from your presence in this regard. What can you tell us regarding your experience in terms of running those programs? and what was your interaction with the students? And that's a side we haven't touched you or poked you on, Osama. So we'd like to hear a bit of that. And Aisha also, I requested to share her experiences.
Aisha, I think you should start.
I should start. Thank you, Osama, and thank you, Emmett Saab. Emmett Saab, when we started this course, as you know, students have also shared their viewpoints, and my experience has been really great because that was the first time mediation, you know, ADR with the focus on mediation was being studied in our university. I, as a law student, I never studied, the focus was never on mediation. Whenever, unfortunately, whenever we talk about alternative dispute resolution, the first thing which strikes our mind is arbitration. So arbitration is being introduced as a course. Arbitration has been, there's been training conducted on arbitration at a vast level. So it was really, I think, learning experience. And also I would like to share one thing, that as mediation focuses on communication skills, so it is very much attached with your other courses at the undergrad level, particularly advocacy skills. Because mediation की जब आप बात करते हैं तो हम mediation course में सिर्फ theory नहीं पढ़ाते. It's always the focus is on communication skills to improve the professional skills of the students. And communication involves a lot of things: your tone of the voice, your body language, words, verbal, non-verbal. So I think this is really an important and pertinent aspect. Young lawyers, students should learn that when they go to the practical field, what type of body language they should adopt, what type of wordings they are using, vocabulary, all of these things. So this is really an important aspect of mediation on which we have really focused on. So our experience has been great. The only issue and challenge we had was lack of resources. I think in our part of the world, it's always a challenge because there's not much work done on mediation. So we are dependent on, books which are written by Western authors. Well, nothing wrong in that, but I really encourage local research on mediation. So I think that is something we are lacking, and probably Usama will also agree with this. कि जब research की बात होती है तो हम काफी, we are lagging behind.
So if I may here, Sama, just give me a second. Sorry, I came in here. I think one of the most challenging aspects is to have indigenous content specific to Pakistan, right? And that was one of the long-term goals of our effort, that when we started on the curriculum project was to develop local case studies. And one of those was to have some action research done by graduate students in the program. And this was something where we are fortunate to have Dr. Atta with us as well. And that's an effort I wish we could have pushed harder for and allocated more resources for, where we could have benefited by having more case studies, because there's a lot of graduate research focus there, and we are fortunate to have some students from Islamic as well. That is one of those things that I felt when we talked about indigenizing content that could be done, and perhaps over a long term we could try to address that. So sorry for my interlude here. Back to you, Sama.
I totally agree with Aisha and what Ahmed Salman Saab just pointed out. जब हमने start किया था, the course that I taught was for University of London students, external LLB students, and that was the first time that the University of London actually started giving the choice to students to opt ADR as one of the elective subjects in the third year. So I think both of these things coincided. And but in the start, obviously, I had to pursue a lot of students to opt ADR as an optional subject in that regard, because most of them didn't know about ADR, what ADR exactly is. So as Aisha just pointed out, when I used to study and during my LLM from Warwick, I took international arbitration as one of the elective subjects back then. So शुरू में हम सबको यही लगता था कि ADR stands for the arbitration. So mediation and conciliation and negotiation and other forms of ADR was something very new even for me back at that time. So I think that teaching students right from the start during their LLB about all forms of ADR is a huge step, because those are the students who are going to be lawyers of the future. So I think if they've studied all forms of ADR, not just arbitration, but mediation as well, so they'll be more accustomed to pursuing mediation or other forms of ADR as career path as well. So I think बढ़ाना students को during their LLB time is basically sensitizing them कि जी सिर्फ आपने वकील बन के litigation नहीं करनी, there are other forms and there are other career paths that you can pursue as well. And with the passage of laws, or जिसमें जिस तरह different laws आ गए हैं, और it's basically it's the start of institutionalizing ADR as a whole. So I think this is a welcome step. और जब आप बच्चों को शुरू में पढ़ाना शुरू कर देंगे तो उनको इतना शौक नहीं लगेगा कि जी अब हम वकालत छोड़ के मीडिएशन की तरफ जाएं या कुछ और करें. तो आई थिंक जब एक बच्चा जैसे लोकल लॉ कॉलेजेस से लोकल LLB करके जब वो आता है, so all he knows about is the litigation adversarial form of dispute. He doesn't know about that there are a lot of other ways. World has advanced a lot, और दुनिया में बहुत different experiments हो रहे हैं कि speedy, cost effective और लोगों का time जो है बचत हो, उसमें उनका dispute resolution हो, because यहाँ पे साला साल जो cases चलते रहते हैं, लोगों के पास इसका time अब नहीं है दुनिया में. So I think in Pakistan maybe we are moving in the right direction. And just wanted to add one thing. Zishan Saab mentioned about Section 89A, B, C in the Sindh में जैसे amendments हुई हैं CPC में. तो I think कि सिंध में तो हुई हैं, that's a welcome step as well. लेकिन पंजाब में जो laws आए हैं वो those are more comprehensive. क्यों वो भी मैं बता देता हूँ कि Section 89A में the word may has been used कि a judge या जो भी may refer a case, ठीक है. और यहाँ पे जो ADR Act आया है 2019 का, words of shall have been used. तो I think shall is mandatory, और जब shall का लफ्ज यूज होता है तो वो judges की एक तरह से obligation बन जाती है. Obviously parties की consent का तो मामला दोनों जगह पे है, लेकिन shall is more comprehensive, more assertive than may. तो I think कि पंजाब में laws तो हमने बड़े जबरदस्त बना लिए हैं, but the problem remains of implementation, and until and unless इसकी स्ट्रिक्ट इम्प्लीमेंटेशन करवाई जाए तब तक ये ऐसी लॉज जैसे हमारे बेतहाशा बनते रहते हैं. एवरी डे देयर इज अ न्यू लॉ, बट व्हाट लैक्स इज इम्प्लीमेंटेशन. तो आई थिंक वी आर मूविंग फॉरवर्ड विद इट, लेकिन वी विल हैव टू लॉबी विद ऑल द स्टेक होल्डर्स कि इसकी जी इम्प्लीमेंटेशन पूरी तरह से कराई जाए.
Osama, can I just make one comment? It's not a question. So my point was perhaps we need to look at the CPC from reform's point of view. Because the provision of 89A is not strong enough, to
Exactly.
encourage people, make it obligatory for them to start referring cases. That was my just one
Exactly.
point.
I think that's really pertinent on that. And it's really fascinating to hear small distinctions that play a huge role in how a program will be eventually, how that framework will play out for us. Aisha, back to you.
Thank you so much, and thank you, Osama. Osama के साथ मेरी जो discussion हुई थी, that was like that Osama is going to talk about approaches to mediation, and then we ended up, talking about more passionately about having mediation in the mainstream line. I just have a quick question to you, Osama, because we planned, for the anatomy, but we ended up, I think, with more fruitful discussion. Is like, do you think that lawyers, of course, probably they are getting aware of the mediation concept, but do you think they are aware of the approaches to mediation? Do they know that what is the process, and what are the various paths they can take to mediate?
Aisha, I think that if you're talking about Pakistan, and because I'm a lawyer as well, I'm a practicing lawyer, and I interact with almost a lot of lawyers every day. So I don't think they know about the ADR laws. Most of the lawyers, they don't know about the new ADR laws and what changes they have brought. So knowing about different approaches to mediation is a longer thing. And I think first of all, we need to sensitize them about the new laws and the rules made therein. and after that they can focus on one form of mediation which they want to pursue or which they want to carry out. So I think mediation जो है इसमें सबसे ज़्यादा जो basic और जो start है, that is mediation. And you talked about, you asked about different approaches to mediation. So I'll briefly lay out the distinctive approaches to mediation कि किस तरह की mediation जो है होती है. Mediation is not just of one type. There are 2-3 different types of mediation. अब तो काफी ज़्यादा उसमें नीचे और भी distinctions आ गई हैं. लेकिन primarily there used to be 2 different approaches to mediation. One was facilitative mediation and the other one was evaluative mediation. So the basic difference between facilitative and evaluative mediation stems from their name. As the name suggests, facilitative mediation. So you have to facilitate both the parties to reach a mutually agreeable solution, a resolution of their conflict. So the mediator asks different questions, validate and normalize parties' points of views, and search for interest underlying the both positions taken by the parties. So the facilitative mediator does not, this is the main distinction, he does not make recommendation to the parties of any sort. He does not give any of his own advice. Hello, can you hear me?
Yes, yes.
And he does not give any opinion about the outcome of the case. So his role primarily is उसने सिर्फ बताना है, parties को टेबल पे बिठाना है और जो भी उनका मामला है उसने उसको हल की तरफ लेके जाने की कोशिश करनी है, दोनों पार्टीज की एक कॉमन ग्राउंड बना के. उसने अपना पॉइंट ऑफ व्यू नहीं बताना, उसने ये नहीं बताना कि एक पार्टी का जो केस है दैट्स मोर स्ट्रॉन्ग, दूसरी पार्टी का केस जो है वीक है. उसने लीगल एस्पेक्ट ऑफ द डिस्प्यूट जो है वो भी नहीं बताना. उस बेसिक काम जो फैसिलिटेटिव मीडिएशन में है वो बेसिकली दोनों पार्टीज को बिठा के और उनकी एक पार्टी का पॉइंट ऑफ व्यू लेना, दूसरी पार्टी का पॉइंट ऑफ व्यू लेना, एंड देन ही हैज टू लुक फॉर द कॉमन ग्राउंड वेयर बोथ पार्टीज कैन रिजॉल्व देयर डिस्प्यूट. So basically what I'll say is facilitative mediation is the primary and true form of mediation. And whether any particular mediator facilitates, chooses a facilitative style or evaluative style depends on the parties of course as well. क्योंकि पार्टीज की मर्जी के बगैर आप evaluative mediation की तरफ नहीं जा सकते. क्यों नहीं जा सकते वो मैं अभी बता देता हूँ कि evaluative mediation जो होती है उसमें मीडिएटर का रोल सिर्फ ये नहीं होता, फैसिलिटेटर का नहीं होता कि उसने दोनों पार्टीज को बिठा के आपस में मामला फैसिलिटेट कराना है और उनको रेजोल्यूशन की तरफ लेके जाना है. evaluative mediation में the mediator takes a more proactive and assertive role. और उसमें जो है उसका काम ये होता है, उसने ना सिर्फ दोनों पार्टीज को आपस में बिठाना है, उनका कॉमन ग्राउंड देखना है, बल्कि इफ द पार्टीज एग्री, ये है if the parties agree, he can also evaluate the claim and the strengths and weaknesses of each of the parties cases. तो इसमें उसका जरा ज्यादा प्रोएक्टिव रोल होता है. और जो lawyers हैं, I think if you're talking about lawyers, तो I think lawyers will always choose evaluative mediation. क्योंकि evaluative mediation इसलिए choose करेंगे क्योंकि उसमें आप legal aspects of a dispute भी बता सकते हैं. और एक पार्टी के, क्योंकि आप एक लॉयर होंगे, आपको पता होगा कि जब आपके सामने केस आए कि किस पार्टी का केस स्ट्रांग है और किस पार्टी का केस वीक है. तो आई थिंक कि यहाँ पे जो है दे कैन आल्सो गिव एन ओपिनियन अबाउट द लाइकली आउटकम ऑफ द केस. तो evaluative मीडिएशन में जरा ज्यादा उनका स्ट्रांग और असर्टिव रोल होता है मीडिएशन का, क्योंकि आप दोनों पार्टीज के स्ट्रेंथ्स एंड वीकनेसेस अलॉन्ग विद द लीगल एस्पेक्ट के लीगलिस्टिक वे में क्या इसकी आउटकम हो सकती है वो भी आप देते हैं. तो ये बेसिकली फैसिलिटेटिव मीडिएशन से एक तरह से कह लें कि नेक्स्ट स्टेप होता है टुवर्ड्स डिस्प्यूट रेजोल्यूशन. और यहाँ पे जो है ये फॉर्मल रिकमेंडेशंस भी दे सकते हैं और इनफॉर्मल रिकमेंडेशंस भी दे सकते हैं. फॉर्मल रिकमेंडेशंस आप evaluative मीडिएशन में तभी दे सकते हैं जब पार्टीज एग्री करें कि जी हमें जो है आप इसका बताएं, evaluate करके बताएं कि what are our chances of winning the case if we take it to court. तो यहाँ पे जो है एक तरह से ज्यादा थोड़ा सा इसमें मैं कहूँगा कि evaluative mediation में coercion का रोल भी आ जाता है कि you can coerce the party कि जिसका केस वीक है कि जी आप यहाँ पे मामला अपना सेटल कर लें. वहां पे अगर आप आगे जाएंगे कोर्ट में तो आपका जो है देयर चांसेस दैट यू लूज आउट. तो आई थिंक ये एक तरह से इसको हम कह सकते हैं कि इट्स एन एक्सेप्शन टू द मीडिएशन. but not a norm. Norm is facilitated mediation. इसके बाद
I
आगे
think,
में
I think Osama, you have made a valid point, and because you know it's very important for lawyers to understand the approaches towards mediation. But I'm really sorry that as we are running out of time, so I just
not an issue. I also have to run for a
wrap up.
meeting.
Yes. So if you would like to say something to just wrap up.
I think that what I'll say is I've just pointed out different approaches to mediation, and we've talked about what needs to be
Yes.
done and what are the key players who are involved, key actors who are involved in this process, and who can implement the laws that have already been promulgated. So I think that the series of webinars that we have launched, and it's the third in the row now. I think the awareness aspect of the laws is the predominant feature of these webinars that we have organized. And I've talked, a lot of lawyers approached me. I was at a function yesterday at Lawyers Get Together, and a lot of lawyers approached me and they told me that we have listened to your webinar on mediation, and they were really surprised that these new laws have already been promulgated, and this is one of the career paths that we can also choose. So I think the lawyer community, as far as I know, is taking this initiative very positively, and यहीं से start होगा और यहीं से बात आगे जाएगी, और इसी तरह अगर हम करते रहे तो I think वो time दूर नहीं कि ये mediation and ADR जो है, it will be the norm, not an exception.
Yes, very true. Thank you so much. Over to you, Ahmed Saab.
Thank you. This has been so enlightening. Usama, we're going to miss you. I hope you can come back. Thank you for really coming in and with your insightful. I would say the insights I've received in our webinars in these conversations has been something that has opened up my eyes to a lot of possibilities, and really appreciate your coming here. And,
thank you, Aisha. Thank you, Salman Saab. Thank you,
Thank you
Ishan.
so much. Thank you so much. Ahmed Saab, are you sharing yours?
I'm getting a few questions, and I was trying to basically engage some of our participants in the chat. I've been asked questions on how much money can be made. Why would somebody be motivated to do this? And I'll just primarily say that we are in the process of making this a profession. So once it's a profession, of course, you can charge your clients just as you would when you are running your own practice, right? So it's not something. The issue of making money is off the table in that sense that if you have a thriving practice of either mediation or any other thing that you do, you could benefit from that. That's one of those things. Can you guys see the slide that I shared with you guys?
Yes, we can see that.
Okay, so awesome. So while we were planning for this, and and I would like to acknowledge two other people who could not be part of our session today. This was Mr. Sarvana, who is the head of Pakistan Mediators Association, and Fauzia Qazi, who is the current president of the Pindi Chamber of Commerce. I wish they were here. They actually gave us this idea how they wanted to conduct their session, and we actually had allocated a longer portion, and unfortunately, we could not have them available for this time frame. And part of it has to do with me because of our 12-hour time difference, and I have I really wanted to, and I'm excited about this effort, but at the same time, not to underscore, it's almost it's 5 minutes to midnight here in Canada, and I've had a full day of work with I think only an hour of break because I was working from 9 to 5, and then I was also engaged in some course teaching till almost 9:45. So had only a limited time to catch up. But I am so excited about the program here, and I still feel refreshed. I've not been able to sit down. I've been using perhaps giving extra information. So I need to stop now. So for this one, we wanted to talk about the anatomy of a mediation, and I felt that me and Aisha had a Vulcan mind meld, and if you are Star Trek fans, you would understand what I'm talking about. Spock was Vulcan, and he had this ability where you could get into someone else's thoughts. And Aisha actually sent me a picture in the morning about frame of reference, and that's what we were talking about. I said, why are we thinking on the same thing? And that's what reminded me of the Vulcan mind meld here. And we'd like to talk about the anatomy of a mediation. And I do have something which I do use in my teaching as well, and perhaps I'll ask those questions. And if you are so kind, maybe you could also go in the chat section and kind of tell me how you would approach that particular problem. For this, I do want to also bring in the importance of negotiation skills. Past couple of sessions, we haven't really talked about this, but and I wanted to throw it out there that conflict is a growth industry. Always has been, always will be, and negotiation becomes a life skill. All of us negotiate every day, but lawyers and people from the legal profession negotiate more than most people, and that's something that comes in very handy. So negotiation and ADR skills are two of the fundamental lawyering skills in the McRae report. This is actually a report which you could look up online. This came out in 1992, and that is when it was identified. Excuse me. And you might see today that I'm speaking more in English because that we do have some international audience also for this program that will be exposed to this. Excuse me. So the other thing that happened, and when I started my day today, I had a conference call in Australia, and the person there at the other end of the line said, spring is just starting, and here we are in Canada where fall is starting, and it got me thinking, what a strange world we live in. Yes, we are able to connect with each other across greater distances, and how we are able to do this program as well. But the fascinating thing is कि जब यहाँ सर्दियाँ शुरू हो रही हैं, वहाँ गर्मियाँ शुरू हो रही हैं. और अगर मैं आज कहूँ जी आज बड़ी सर्दी थी और अगला मुझे कहो कि बड़ी गर्मी थी आज मेरे पास, तो पागल है यार, किस जगह पे है ये? तो हम लोग we really need to spend our time and understand the frame of reference where the other person is coming from. So there's a very interesting situation, and that is related to this. It's called the Coriolis effect. Coriolis effect basically एक आपने शायद सबने देखा होगा, कई YouTube पे वीडियोस चलते हैं जिसमें वो ये कहते हैं कि जी आप जरा देखें तो सही कि आप जिस हेमिस्फीयर में रहते हैं, पानी आपका जब ड्रेन हो रहा होता है वो किस डायरेक्शन में जा रहा होता है, वो क्लॉकवाइज जाएगा या एंटी क्लॉकवाइज जाएगा. तो एक छोटा सा मैं क्लिप प्ले करूंगा आप लोगों के लिए. I hope the sound comes in, but it's really fascinating, and it's about optical illusions, what you see in front of you and what you think, and how this could be added to the or would make you question your own faculties. So I hope you can hear the sound.
Canadians are responsible for 1/5 of the world's fresh water. Even at home, we can save water as easily as skipping the rinse before loading the dishwasher. Together, we can set an inspiring example for an increasingly water-challenged world.
With a simple game of catch, I think I've found a way to show an effect that will have you doubting your very own eyes. Now, they don't know it yet, but our budding ball players sitting on our specially rigged merry-go-round are about to demonstrate a rather astonishing optical illusion.
Right, here's the game, right? You're going to throw the ball straight to, what's your name, Victor, right? Yeah. But this time, I'm going to complicate things slightly. I'm going to rotate the merry-go-round counterclockwise. So you throw it whilst it's moving. What's going to happen?
I don't know why, but I feel like if we're going fast enough,
yeah,
like I might actually be the one catching the ball.
Okay, so you're going to throw it and you're going to catch it. All right.
Yeah, I don't know.
Right, what's going to happen, dude?
I was going to veer off to the left.
So the ball is going to swerve off to the left.
Yep.
And you might catch it.
Possibly.
Okay, good. Right, so what's going to happen?
I think it's just going to come straight to me, and I'm going to catch it like the champion that I am.
Show me the catch. Okay, great. Right, okay, is that everyone? No, hang on, one more.
He's not arrogant.
Just quietly
He's
confident.
not catching it. He's
Really?
not catching it, no.
So what's going to happen to the ball?
I'm catching it. It's right here.
Great, so we've got one saying to go off to you, one saying to come to you, Spencer, and you think it goes straight ahead, but you think you'll be the one catching it.
Yeah.
Now remember, the ball will be thrown straight across the spinning merry-go-round, but where will it end up? Will it be caught by the thrower? Will it be caught by the person opposite? Will it be caught by the person to the thrower's left? Or by the person to the thrower's right?
Right, in your own time, throw the ball.
I got this. Oh!
I told you it was gonna happen.
So the answer was D. It was caught by the person on the thrower's right. Our camera angles seem to show the ball bend in the air. So is that a camera effect, or are we seeing what they saw?
Hang on, this couldn't get much more simple. The idea was just to throw the ball straight to Victor to show us his amazing catching skills.
That's right.
Yeah, it did. It just curved right over this way.
So let me get this straight. So you threw the ball, it left your hands, and then what?
And then it just got sucked over to him.
In the air.
Yeah, I threw a perfect throw.
What did you see?
Yeah, curved right in.
Right, so we're all agreeing here the ball curved in midair.
Yeah.
Yes.
And you didn't cheat this at all?
No, I didn't.
Okay. And do you know why it did that?
No.
Nope.
No idea.
It's called the Coriolis effect. And it's very simple. It's objects in motion appearing to be. It's an optical illusion.
So I'm pausing this here. It made its point that what we see may not actually be what we are, what's really happening, or our eyes might deceive us. You may have seen other things as well. Aisha did share that picture, and perhaps I'll bring it back. You might have heard this story about a team of blind people or blindfolded people who are taken to a site where there is an elephant, and they can only tell by touching objects where they are and what they are experiencing and what they are seeing. So when we talk about frame of reference, what do you see? Somebody who's in front, who's touching the elephant's tusk, what does he see? उसे नजर आ रहा है कि ये तो उसका जो हाथी के दांत होने चाहिए थे. वो कहता नहीं, this is a spear because it's a pointed object. जो हाथी के ऊपर है वो कह रहा है कि ये तो पंखे हैं यहाँ पे. जो हाथी के साइड पे खड़ा वो कहते हैं दीवार है ये. जो पीछे खड़ा कहते हैं तो रस्सी है. जो ट्रंक के साथ खड़ा कहते हैं तो कोई दरख्त है. और जो ऑफ कोर्स उसके जो है सूंड के साथ खड़ा है वो कह रहा है कि इट्स अ स्नेक. सो इट्स अ मैटर ऑफ परसेप्शन कि कौन किस जगह पे खड़ा है, क्या चीज उसके सामने और उसे क्या नजर आ रहा है, और उसके बाद जो है वो उस पे जज करेंगे कि what's really going on. So within this, I'm going to actually show you a few more visuals, and these are really powerful that we use in our mediation programs. What do you see in this visual? And perhaps I would appreciate if you can chat में अपने answers जरूर लिखें. What do you see? So this is where you have perhaps a bunch of angels negotiating with a bunch of devils, and you see that the caption says, then it's agreed. But let me show you another visual. What do you see now? The situation has been reversed. You have where you had the devils, you have the angels, and where you had the angels, now you see the devils. So it's a matter of perspective where you're looking at it from. And in this, how I usually view it, that there are always two or more sides to every story. If there were not, a frame of reference as a concept that we really need to understand. So for somebody may be drowning in that amount of water, and the other one would say, hey, you got to be kidding me. It's we're not drowning, or you're not drowning. You're just going through that thing and you're overreacting. It's not that deep. But it's again our frame of reference that plays a huge role there. ये पहली चीज है. दूसरा, उसामा ने communication skills के ऊपर touch किया था. So अगर आपको याद हो, in our first session we did talk about the Kilpatrick model conflict, and I will get to that, but I wanted to introduce a couple of other models today, which are some fascinating models on to really understand the communication phenomena that we deal with. you might have heard of the Joe Harry window, and you might think ये Canada में बैठ के ये जौहरी को ये Joe Harry कह रहे हैं, but it's actually Joe Harry, which is based on Joseph Luft and Harrington Ingham paper in 1955. And they came up with a model where they said, you know, when you are in any situation and you talk basically exposed to new people, or so there are two scenarios when you meet somebody new. When somebody's an unknown commodity, and that let's say two parties come together and you are a mediator और आप एक dispute resolve करने जा रहे हैं, तो आपका लिए इस मॉडल की क्या इंपॉर्टेंस है? और जो हैरी विंडो की जब हम बात करते हैं तो इसमें इन्होंने 4 क्वाड्रेंट्स में डाला हुआ है। एक तो ये है कि जी आपके बारे में कोई ऐसी चीजें जो आपको भी पता है और लोगों को भी पता है, मे बी वो आपको देख रहे हैं, दे कैन विजुअली सी यू कि व्हाट्स द मैनरिज्म ओवर देयर, लेकिन कुछ चीजें जो उनको नजर आ रही हैं और आपको नहीं नजर, यू known to others but not known to self, which is a blind spot. जो उसके बाद नीचे अगर हम आते हैं तो known to others but unknown to others but known to you, which is a hidden area or a facade, कि आपको पता है लेकिन आपने अपने आप को मास्क किया हुआ है। और चौथा ये है जिसमें ना आपको पता है ना उनको पता है, और ये एक एरिया ऑफ अपॉर्चुनिटी है। ये मीडिएटर के लिए ये एक मॉडल जो है इट काइंड ऑफ brings everything in, and from a very high level of thinking and also from a practical point of thinking अगर हम इसको देखें। there are a couple of other figures, तो हम उसमें ये बात देखते हैं कि जी कुछ ये जो sizes हैं quadrants के ये change हो रहे हैं। क्यों हो रहे हैं? Because the more you talk to somebody, you start discovering more about the other party, or the more you interact with someone, you start discovering, और उस डिस्कवरी के प्रोसेस में आपका जो ओपन एरिया जो हम पहले वाले में देख रहे थे, ओपन एरिया नोन टू सेल्फ और नोन टू अदर्स वाला, आप उसका साइज देखें कैसे वो बढ़ता जा रहा है। और जस्ट बिकॉज देयर इज डिस्क्लोजर, यू हैव आस्क्ड फॉर फीडबैक, एंड द अदर साइड्स दे स्टार्ट ग्रोइंग डाउन। आइडियल तो ये होता है किसी भी सिनेरियो के अंदर कि आपका जो ओपन एरिया है वो कंप्लीट, एंड दैट वुड बी ए वेरी स्किलफुल मीडिएटर, ए वेरी open-minded team of people who are there in good faith to get a resolution for their cases, कि वो इसके ऊपर जो है ओपन एरिया के अंदर जाके वहीं जाके आपकी डिस्कवरी होती है। लेकिन उसके अलावा एक चीज, एंड आई वांट टू कम बैक टू दिस वन, जो अननोन वाला जो है, ये इसको एरिया ऑफ अपॉर्चुनिटी भी कहते हैं। क्यों कहते हैं? बिकॉज ना आपको पता है ना किसी और को पता है कि होना क्या है, कैसे होना है, और उसमें आपके हो सकता है कोई ऐसी बातें डिस्कवर हो which can help you with this। ये एक इंसान जो है, वैसे तो हमें नहीं पसंद, मुझे नहीं पसंद, डोनाल्ड रम्सफेल्ड जो है जॉर्ज डब्ल्यू बुश के जमाने में सेक्रेटरी ऑफ स्टेट था और बड़ा जो है एरोगेंट इंसान भी था। आई विश आई कुड प्ले दिस वीडियो फॉर यू, लेकिन वो टाइम लगेगा है तो और उसका वीडियो का ही टेक्स्ट ऊपर लिखा हुआ है। He was asked a question about certain failures in the Iraq war. तो उसने कहा, and I will read it out to you and you will see how absurd it sounds. There are no knowns, there are things we know that we know. And then there are known unknowns, that is to say there are things that we now know we don't know. And finally, but there are also unknown unknowns, there are things we do not know we do not know. Everybody started laughing. And when they did, this was an interesting, और जब इसने अपनी किताब लिखी रिटायरमेंट के बाद, अपनी बायोग्राफी लिखी, actually titled it Known Unknowns, and that's, or maybe I'll just play it for you. I hope
there are reports that there is no evidence of a direct link between Baghdad and some of these terrorist organizations.
There are known knowns. There are things we know we know. We also know there are known unknowns. That is to say, we know there are some things we do not know. But there are also unknown unknowns. The ones we don't know, we don't know.
Excuse me, but is this an unknown unknown?
I'm not.
Several unknowns, and I'm just wondering if this is an unknown
I'm not going to say
unknown.
which it is.
So जब ये आया था पहली दफा ये क्लिप, तो everybody made fun of it. But you know, we as negotiation and dispute resolution academics, we looked at this and we said, you know what, बंदा तो ठीक नहीं है लेकिन बात बड़ी पते की कर गया। और उसके ऊपर फिर बहुत सारे मॉडल्स जो है वो डेवलप हुए, which is very interesting. So I've actually, if you now look above the clip, what do you see? Known knowns are facts, जो के कहाँ नजर आ रहे हैं हमें? Known knowns. This is where we are. Known, known. ये quadrant मैंने बनाया हुआ है. दूसरा है known unknowns are areas where we need to ask questions. Unknown knowns is where sometimes the intuition comes in. It could also be questions plus intuition in both those quadrants. लेकिन unknown unknowns का जो area है वहाँ पे exploration जो है that is really key to discovery. मैंने पिछले sessions में बात की थी कि एक बहुत important skill है questions पूछना, और वो वाले questions पूछना जो कि आपको वो information दें which doesn't come any other way. And if we are able to uncover facts about the case that or interest of the parties, or and then so that would lead to, so I am actually going to do a small thought experiment with you, and this is one of those academic exercises, but this is for everyone. And I appreciate that some of you did try to, so I would want you to start thinking and think about this with me. It's called the ugly orange conundrum. By the way, ugly is a place in South Africa, और वहाँ पे जो oranges grow होते हैं उनका brand है ugly orange, and this is one of those things. So ये हम उर्दू वाली ugly या अंग्रेजी वाली ugly पे ना जाएं तो बेहतर है. लेकिन so I would like to introduce, but at the same time कुछ visuals जो मैंने इसमें डाले में वो एक visual तो थॉमस और किलमन का जो कॉन्फ्लिक्ट मॉडल था जो मैंने पहले वेबिनार में आप लोगों के साथ शेयर किया था, and I'm going to kind of use that as a framework to look at those scenarios. Plus ये था कि distributive और integrative की या उसामा भी बात कर गए, so it's very nice that now we can actually start looking at this कि जी conflict के अंदर कौन से factors हैं, और that's why I said the anatomy of a mediation, what really is something that would encompass a dispute resolution exercise, and how a mediator or a dispute resolver can come in that scenario or what. So what you see here are two sisters, and these two sisters, and you can obviously see they're not talking to each other. They only have one ugly orange in the house, and they both want it. So if this is an exercise, I give this exercise in a classroom scenario, and I say, you know what, okay, so now you have to negotiate, and you know, you need to come up with a solution, and it could be any number of solutions that we see here below. It could be a win-win solution, it could be a win-lose solution, it could be a compromise solution, it could be an accommodating solution, it could be an avoiding solution. और ये थोड़ा सा इसमें मैं बता देता हूँ, ये मैंने पहले विन लूज की भी बात की थी. उसमें ये था कि जो विन विन है, ऑफ कोर्स दैट्स ए गुड आउटकम, लेकिन अगर आप अब इसमें मैं ये चाहूंगा कि आप ये सोचें कि व्हाट वुड बी ए विन विन सिनेरियो. दोनों को अगर हम जो है आधा आधा ऑरेंज, इज दैट विन विन या वो कॉम्प्रोमाइज है? वी नीड टू लुक एट दिस के विन विन क्या होगा. और जो इम्पोर्टेंट बात है कि हमें ये देखना है कि द पर्पस ऑफ आवर एक्सरसाइज is, and I'm going to throw in the operative word here, we want to expand the pie. Does giving each one of these sisters half of this orange, does it ever expand the pie, or it split the pie there in the middle, right? So that's one of those things. They could be competing with each other. It's a win-lose. One of them says, I need it, and one of them could go running to mom and dad and say, you know what, I'm going to get it, and starts throwing tantrums, and that person wins by being more assertive, right? And you have a cooperative person who says, okay, you want it, go, you got it, but that person does lose, so that accommodation doesn't really result in expanding the pie, or it's not a desired outcome in this scenario. Of course, if the parents say, you know what, we won't give it to either of you, go, and neither of you is getting this, of course that's a lose-lose scenario. Or if they end up stomping on it and just destroying that orange, So that's it. I know Aisha is prompting me, so I'll just try to quickly wrap it up. Aisha, give me a couple of minutes, please. Thank you. This because this sets us up, and this is important. So I want you guys to start thinking. अगर एक बहन है वो कहती है मैं बड़ी बहन हूँ, सवाल ही पैदा नहीं होता कि मैं तुम्हें दूं, मैं मेरी पावर है, मैं जो है, but they could also come out, वो उसे कहा कि अच्छा तुम ऑरेंज मुझे दे दो, इसके बदले में मेरी ये चीज ले लो. That is also one way of approaching that. कुछ resolve करने. जो एक चीज इसमें सोचने वाली है वो ये है कि एक्चुअली दोनों को ऑरेंज चाहिए क्यों है. ये सवाल नहीं अभी तक हमने पूछा. या तो अगले को तंग करने के लिए चाहिए कि इसने मांगा है तो मैंने भी मांगना है, जो कि हमारी एक टिपिकल मेंटालिटी है. लेकिन ये भी समझने की जरूरत है किसी और भी वजह से हो सकता है उसको ऑरेंज चाहिए. तो इफ वी माइट फाइंड आउट कि एक ने सिर्फ उसका जूस पीना है और दूसरे ने जो है वो उसके जो छिलके से वो केक में उसको इस्तेमाल करना है राइंड को, तो दोनों की तो उसके इस्तेमाल ही डिफरेंट है. बट हाउ कैन वी डिस्कवर दैट वो जो अननोन है कि ना इसको पता है कि उसे क्यों ऑरेंज चाहिए ना दूसरी को पता है, तो फिर व्हाई हाउ कैन वी एक्चुअली गेट टू दैट स्टेज वेयर वी फाइंड आउट कि ये व्हाट इज इट दैट. तो विन जो है वो कैसे अचीव हो सकता है, और अगर विन विन नहीं हो सकता तो क्या यही 5 आउटकम्स हैं या इसके अलावा भी कोई आउटकम है. और जो इसके अलावा आउटकम्स हैं वो उस पे मैं क्विकली, वन मोर मिनट आयशा, सॉरी, एंड आई एम जस्ट ट्राइंग टू गेट देयर. ये देखिएगा सवाल ये पैदा होता है, और एन फ्रैंक ने भी कहा था कि आप अगर पूछेंगे नहीं तो आपको पता नहीं चलेगा. तो पूछना जो है वो लाजमी है. मुख्तलिफ इकसाम के डिस्प्यूट्स हो सकते हैं एंड वी कैन परहैप्स इफ वी फाइंड द टाइम, लेकिन ये देखिएगा कि पाई को एक्सपैंड करने के लिए या ट्रेड ऑफ्स ऐसे करने के लिए जो दोनों के लिए एक्सेप्टेबल हों, आपको बहुत ध्यान से सोचना पड़ेगा. और वो ध्यान जो है वो या तो विन विन होगा या आप कहेंगे कि ठीक है हमने कोशिश कर ली है, लेट्स ट्राई समथिंग एल्स. विन विन और नो डील, जिसमें आप ईगोस को भी एड्रेस कर सकते हैं. नोबडी लूजेस. अगर तो विन विन नहीं हो रहा, गुड फेथ में एफर्ट की, कॉम्प्रोमाइज की तरफ भी जा सकते हैं, लेकिन कॉम्प्रोमाइज के अलावा भी एक आउटकम है जिसमें कोई पार्टी लूज नहीं करती. दैट इज नो डील. यू कैन वॉक अवे, एंड दैट इज वन थिंग दैट वी नीड टू रियली स्टार्ट टॉकिंग अबाउट. एंड perhaps when I come back at the tail end to wrap this up, I will share something else with you. Thank you, Aisha.
Thank you so much, Amitabh, and I'm so sorry. I think you're talking about ugly orange, and I have the ugly job to interrupt the speaker and just let them know that time is up. Of course, it is really interesting conversation, but we need to, take care of the time as well. I'm really honored and glad that Hassan Khan has joined us, and Hassan Khan is a young lawyer who is very enthusiastic about mediation and how the mediation can be in the limelight. He has over 10 years of experience in legal field, and he has done a lot of practice from IP to corporate to banking sector. Thank you so much, Hassan, for joining us. And before you say something, I think you need to, yes, no, you're unmuted. So before you say something, I have a question for you. What, in your opinion, is the reason that courts are so jammed up by the cases? Is it the number of judges, or is it the number of the lawyers who are representing clients? Where we are lacking? Why courts are so docked up and they are jammed up with the cases, and the cases have been continued for over years and over generations? So what is the reason behind?
Aisha, thank you very much for having me on this webinar, and I think it's a very important discussion which is going on right now, and I think it is the most important issue right now, to be honest, as a lawyer, which I think over a lot of times, because honestly, if you see a person suffering in courts, obviously at the end of the day we all are humans, and we also feel that things should actually conclude in a very timely manner. So, but coming up to your question, basically I would say that frivolous litigation basically is also one of the most important factor for us, that there is a lot of cases, that the inflow of cases is so much that probably it outnumbers the amount of judges we have to take care of them. I still remember in 2009 when I joined practice, I used to ask myself that there is a single judge who has to deal with around 150, 175 cases in one day. And how is it humanly possible for that one person to take up these much cases in one single day? So over the number of years, what I have come to realize that the judges have increased, but the litigation has increased so much that it is still there where it was 10 years ago. So that is why I think the issue we are discussing right now needs to be going up on the stage of importance to a very scale that we address, implement it, and follow it as much as we can.
Yes, I think you're right. We are suffering from frivolous litigation where people actually enjoys to go to court and litigate, maybe. So, what, in your opinion, should be the way and should be the process where mediation, could become the first resort for dispute resolution?
See, Aisha, basically, we need to first understand that there are no prizes for taking up cases to courts as a matter of first resort. So we need to first understand that. And the mindset we have in our society is mainly based towards litigation. If you would see minor disputes we come across every day, which could be resolved in one sitting, but people would be adamant to going towards courts and litigation, and they would want to initiate litigation process because the mindset is towards litigation. See, this not only, I think, affects a person's state of mind, and also it would affect, or it would basically give rise to other disputes. See, I have come across many scenarios in which there would be a small dispute which would start among parties who would have started litigation, but then it would become a matter of ego amongst them. And then it would result in a number of frivolous litigations which would start because of that one single issue. And why? Because they resorted to litigation and they never thought that there could be an amicable settlement to this issue as well. And number of times it results in crimes being committed just because why did you go to court against us at the first place, and we want to deal with you in other ways. You know how people think. So I think the approach as far as creating awareness amongst the general public is concerned, that is there, and then we should do that, and we are doing that as well. But creating awareness amongst the upcoming lawyers is also important. See, I still remember in my first year of law, when I was studying English legal system as a subject. In that subject, we came across a case in which the court in United Kingdom, it actually penalized a plaintiff for not taking up the offer of the defendant, the pre-trial offer of the defendant, seriously, even though the defendant had won the case, but they made sure they penalized him. So I, as a lawyer, I had that thing in mind, that what an amazing view the courts have adopted. That, if Aisha, I offer you a pre-trial offer of 100,000 rupees and you get 80,000 after 10 years, imagine what the time you would have saved of the courts and your own time and my time by taking up that offer seriously, which you did not take. So here in Pakistan, courts need to start taking up that perspective as well. We see in High Court as well now, some of the judges who have started imposing costs on frivolous litigation, which is quite nice, because we need to put an end to an inflow of this frivolous litigation and take up serious matters. So that is why I think mediation, coming to your question, is basically very important. And why am I talking about frivolous litigation so much? Because see, in any state or wherever you go in one of the most developed nations as well, there are basically three things which are of utmost importance: access to education, access to health, and access to justice. Most of the people, they would remember access to education and health, but they don't know that access to justice is the foremost pillar of a state. And if there is no access to justice, there are no basic human rights. If there are no basic human rights, what an individual's stance in that society is, you would know better. So basically, that is why the access to justice will only be possible if we take steps to curb the frivolous litigation, and we also adopt the alternate dispute resolution mechanisms there are.
Very true, very true. Thank you so much, Hassan. Seriously, it was a good insight you have given us, and the important point you have just raised is access to justice. We normally do not take access to justice as one of the fundamental rights, and what basically comes into access to justice is also we are unaware of it. The cases have to be decided timely, because if your case has been decided after 50 years or 60 years, that's what we actually see in some cases here. So there is no point probably of winning, and there is no joy of winning, because the time, the energy, the money you have spent on that case actually subsides every other sense of achievement. So probably mediation should become in the mainstream in this context, that it gives you a sense of achievement. It saves you a lot of time, a lot of hassle, and I think it's a win-win situation for our judiciary system and for our people at large. It's a win-win situation for both. Thank you so much for such a great insight, and we are honored to have you on board. Our next speaker for today is Barrister Scheherazade. And Barrister Scheherazade is an advocate of High Courts and is currently working in Ahmed and Basota. She is also a member of Standing Committee on Mediation in Lahore Chamber of Commerce and Industry for 2020. Thank you so much, Barrister Scheherazade, for joining us. And we would really like to listen from you that, what are the process of mediation? What is it? And do you think that lawyers are, because I'm asking this question to almost every speaker, do you think that lawyers are aware of this, this process, that how it works? Because mediation probably हमें समझ में आता है, लेकिन उसका process कैसे है, उसको कैसे आगे लेके चलना है, what is the sequence, what are the stages? Do you think that lawyers are aware of it?
Hi, thank you. Assalamu alaikum, everyone. I don't think lawyers are aware of it, because obviously हम ऐसी सोसाइटी से बिलोंग करते हैं जहाँ हमें ज़्यादा पैसे बनेंगे, हम वो चीज़ करने की कोशिश करेंगे. सो मीडिएशन तो एक ऐसी चीज़ है कि बिकॉज आप देखें कि जो एक रेगुलर लॉयर है, उसने आपसे अपफ्रंट फीस नहीं लेनी, आपसे हर पेशी की फीस लेनी है. अगर वो आउट ऑफ सिटी है, उसने हर ट्रैवलिंग कॉस्ट आपसे लेना है. सो ऑब्वियसली वही बात जो पिछली दफ़ा हारून साहब ने भी की थी कि इट इज़ अ ब्रेड एंड बटर ऑफ अ लॉयर, एंड ऑब्वियसली दे डू नॉट वांट टू एंगेज इनटू मीडिएशन. बट मीडिएशन का जो प्रोसेस है वो सबको समझ इसलिए आना चाहिए बिकॉज कोर्ट्स का बर्डन हमने एट वन पॉइंट जाके कम करना है, ताकि हमारी जितनी भी जजमेंट्स पास हो इस तरह की हो जिसमें लॉ डेवलप हो, rather than कि हम उसी एक उसमें फंसे रहें. बिकॉज एवरी अदर कंट्री इज 60 years superior to us because of the fact that they develop law. हम लोग इतना बैकलॉग रखते हैं कोर्टों में, इतनी फ्रिवलस लिटिगेशन करते हैं जिसकी वजह से हमारा लॉ उस तरह नहीं डेवलप हो सकता. सो इसमें मेरी तो रिकमेंडेशन यही है कि ऑब्वियसली लॉयर्स शुड बी अवेयर ऑफ दीज प्रोसेसेस, एंड टिपिकली देयर आर 4 processes of mediation. First is the opening stage, second is the consideration stage, third is the bargaining stage, and fourth is the settlement stage. So I'd just like to quickly go over every stage. The first stage being the opening stage, they should start like the mediator should have an opening speech. He should set the tone of the day. ये बड़ी एक इन्फ्लुएंशियल स्पीच होनी चाहिए जिसके अंदर पार्टीज को ये पता होना चाहिए that the mediator is not there to decide the case. He is there to reach a settlement and to help them. इसमें बड़ा एक मेजर फर्क है, बिकॉज जहाँ पे आप आर्टिफिशियल वगैरह में चले जाते हैं वहाँ पे डिसीजन मेकिंग पावर आ जाती है. With mediation, you are acting as a neutral and an impartial party, where you have to obviously अगले बंदे को आपने हेल्प फील करवाना है कि जी हम आपको डिसाइड नहीं कर रहे आपका केस, बट वी विल रीच अ सेटलमेंट फॉर यू. So the mediator has to set the tone of the day. And obviously, before starting anything, he or she should tell the parties present there about their qualifications, about his qualifications, about the training that he has received. उसने party को ये भी ensure करवाना है कि yes, of course, I am a mediator and I have the requisite qualifications and the requisite training to conduct this mediation. Until unless he doesn't do that, पार्टीज के अंदर वो कॉन्फिडेंस नहीं आएगा कि ये मीडिएटर हमारा कोई भला करने आया है. ऑब्वियसली इसके साथ साथ जो इसकी ओपनिंग स्पीच है, when it sets the tone of the day, then the parties will also know what to expect from this mediation, which is very, very important. They must know that they're expecting to reach a settlement and that, or the mediator is expecting them to reach a settlement. And iske karne se he must then obviously in his speech ensure that this is a confidential process, this is a neutral process, and this is an impartial process. He has to very clearly state that. ऐसे नहीं कि read between the lines वाली चीज उसने नहीं करनी, उसने ये चीज बड़ी clearly parties को set करनी है. उसके बाद in being in this stage, जो opening stage है, उसके अंदर हम आगे जाते हैं जहाँ पे the mediator की opening statement के बाद जो parties हैं वो one by one अपनी opening statement दें. One by one अपनी opening statement देने का ये मतलब है कि they must air their views. They must tell what their problems are, what the dispute is, how they want to manage the case, what do they want. जब वो एक दफा टोन सेट हो गया, उसके बाद वो अपने इश्यूज बताते हैं, सारा कुछ करते हैं, तो ऑटोमेटिकली मीडिएशन उस तरफ चल पड़ेगी. दोनों पार्टीज को स्ट्रेंथ्स और वीकनेसेस अपनी केस की एकदम पता चल जाएंगे. बिकॉज कभी कभी ये होता है कि हम अपने दिमाग में सोच रहे होते हैं कि ये बहुत अच्छा केस है, हमारे फेवर में है और हम तो इसको जीत जाएंगे हम अगर कोर्ट चले जाएं. बट व्हेन यू स्पीक इट आउट और व्हेन यू थिंक इट आउट लाउड, ऑटोमेटिकली आपको अपने वीकनेसेस एकदम पता चल जाते हैं. सो दिस इज रियली इंपॉर्टेंट इन द ओपनिंग स्टेज कि मीडिएटर भी अपनी ओपनिंग स्टेटमेंट दे, हर पार्टी भी अपनी ओपनिंग स्टेटमेंट दे. इससे ही फ्लो करता है मेरा नेक्स्ट स्टेज, विच इज द एक्सप्लोरेशन स्टेज. Why do I say the exploration stage? Because once the mediator knows in every party's opening statement what the parties are expecting, he will know how difficult the parties are. He will know how difficult the settlement is. And then he can maybe decide to have an open joint meeting with the parties or a private meeting with the parties. Joint meeting से ये मुराद होता है कि आपको jointly handle करना है, दोनों को आपने फेस ऑफ नहीं कराना पार्टीज का, आपने कोई लड़ाई नहीं करानी पार्टीज में, आपने उसको हैंडल इस तरह करना है कि दोनों के इमोशंस, दोनों का अग्रेशन, दोनों की हर चीज आपने स्मूथली हैंडल करनी है. जहां पे मैं ऑब्वियसली मी बीइंग अ लॉयर, मी बीइंग involved in this mediation process and everything, I would recommend that there would be private meetings. उसकी मसला ये है कि because we as a nation, we as a society are very aggressive in nature. 90% people over here in Pakistan are very aggressive.
So, Shehzad, ijazat dijiyega एक minute. I think you got that point, and it's a very interesting point. There is a very real threat of violence in some of those cases. And maybe we're not equipped as mediators to stop that violence. The only thing is we can set those ground rules right. That's first. Second, of course, a very important component after the opening one is to promise confidentiality and impartiality. Tisri cheese, holding separate caucuses, and you only bring the parties together when the ground rules have been agreed upon, and you know it's a safe aspect to bring them back together in front of each other if that is where it has headed to. And if it is not there, of course, ये जो एक element है, जो private caucuses वाला है, that is key to this process in this regard. कि अगर आप caucus नहीं कर सकेंगे private meetings के, तो फिर वो प्रोसेस आगे मूव नहीं कर सकता। और इसमें एक और एलिमेंट है, सॉरी मैं इसमें, वो ये है कि आप जो एक पार्टी से बात करते हैं उसकी वो बात दूसरी पार्टी से सिर्फ उसकी इजाजत से शेयर कर सकेंगे, and that's what builds credibility, and that is what your commitment is as a mediator. So I really appreciate you coming back for this program. Or we have such insights that, and this is so insightful for the students or for the junior lawyers who are considering a career in this side. And I'm seeing some of those questions come in. What do we really need to do to set up a practice, or how is it that we can go there? And we perhaps hear more. We do have a couple of amazing speakers in the lineup, and we are really running out of time. So, really appreciate Sherzad. Thank you. And Aisha, back to you.
Yes. Thank you so much, Sherzad. And the moment she talked about the aggressive nature, so I was just thinking that for adversarial litigation, this is beauty of adversarial litigation, to be very aggressive and violent when you are in a courtroom. So that's the main characteristic attached to adversarial litigation. Thank you so much, Sherzad. And our next speaker is Barrister Taimur Malik, and it's always a pleasure, to professionally and personally to introduce Barrister Taimur. Barrister Taimur is partner at Kinnaird Co. and is also the founder of Pakistan's leading law and justice initiative, Quoting the Law. His experience includes advising governments, sovereign wealth funds, financial institutions, listed companies, and Fortune 500 companies on a wide range of contentious and non-contentious matters, including arbitration, litigation, and mediation mandates. He's an expert in commercial context, and when I said that it's always a personal and professional pleasure of introducing Barrister Taimur and have him on board is that Barrister Taimur and his family is basically one of the pioneers behind the establishment of Nadira Hassan Law Department. So it's always a pride and a proud feeling whenever he's here, because Nadira Hassan Law Department jitna hamara hai utna hi Barrister Taimur ka bhi hai. And I worked with Barrister Taimur, so I know that he's very hardworking and he's a true role model for young lawyers. The achievements and the work he has done. So thank you so much, Barrister Taimur, for taking out time and always agreeing, to be on board. Thank you so much. We are honored.
Thank you, Aisha. Very flattering introduction. So thank you for that, as always. It's equally a pleasure to be here, and I was on mute and listening in to the previous speakers. I think an excellent initiative by you and the Institute, as well as Asia Foundation. So I think this is very important in the context of not just Pakistan, but internationally now, that ADR methods are used for dispute resolution, or mediation, of course, is a key part of that. मैंने जैसे आपने जिक्र किया, मेरा आज का जो डिस्कशन का फोकस है, थोड़ा सा I would like to discuss in the context, in more of a commercial context, because मैंने देखा है कि पहले speakers ने भी जो कि एक procedural structure है of a formal mediation, वो तो बहुत अच्छी तरीके से explain किया जा चुका है over the course of the previous days as well, और आज भी. So I would like to say कि actually in reality, in practice, मैं क्या देखता हूँ. So those of you who don't know me, I'm a partner at a global law firm, Kinnaird Co, and work really across different countries. I'm abroad at the moment as well. And in the past, of course, I've been doing public international law work, जहाँ पे mediation या discussions या negotiations between countries हो रही थी ज़्यादा, or at multilateral forums or bilateral forums. But then over the last decade, I have done mostly commercial work. So when I say commercial work, that means in a contractual framework, shareholder disputes, joint ventures, public-private partnership issues, and so on. So एक चीज़ को तो हम, और मैं commercial context पे क्यों आज focus करना चाह रहा हूँ, because देखें हम पाकिस्तान में, मैं जब भी किसी से mediation की बात करता हूँ या सुनता हूँ, तो वो ज़्यादातर इस कॉन्टेक्स्ट में हो जाती है कि जी वो फैमिली मैटर्स या प्रॉपर्टी डिस्प्यूट्स, उस तरह के मामलात के अंदर मीडिएशन को देखा जाता है और समझा जाता है कि जी ये अच्छा तरीका है। लेकिन जहाँ कमर्शियल डिस्प्यूट्स की बात आती है, बिकॉज एक हमारा एडवर्सेरियल सिस्टम है और आप किसी वकील के पास जाएं तो वो पहले ये कहते हैं कि जी हम इसके लिए रेंडेशन ऑफ अकाउंट्स का सूट फाइल करते हैं, या हम कंपनी की लिक्विडेशन का केस फाइल कर देते हैं, हम कुछ और करते हैं। वो एक डिस्प्यूट अगर दो शेयर होल्डर्स का या एक क्रेडिटर और डेटर का शुरू होता है तो उसमें बिफोर द पार्टीज इवन गेट टू टॉक टू ईच अदर मल्टीपल केसेस एक दूसरे ने दोनों पार्टीज के खिलाफ फाइल कर दिए होते हैं और वो डिफरेंट फोरम्स पे चल रहे होते हैं। उसमें डिपेंडिंग ऑन हु इज रनिंग द कंपनी और किस्म की एलिगेशंस भी आ जाती हैं एंड थिंग्स कैन गेट रियली बैड। जो मैं इंटरनेशनल फोरम्स में अब देखता हूँ, और इनफैक्ट अगर मैं या मेरी टीम कोई एक कमर्शियल कॉन्ट्रैक्ट ड्राफ्ट कर रहे हैं तो आई मेक श्योर कि मैं डिस्प्यूट रेजोल्यूशन क्लॉज को देखूं एंड वुड ऑलवेज प्रेफर कि उसमें पहले एक मीडिएशन की विंडो होनी चाहिए। और मीडिएशन की जो विंडो है वो चाहे 60 डेज की हो या 90 डेज की हो, जो भी हो, बिफोर पार्टीज कैन गो टू आर्बिट्रेशन और लिटिगेशन। And that's very important because दोनों पार्टीज अपनी लीगल कॉस्ट इनकर करना शुरू कर देते हैं एक दफा अगर आप डिस्प्यूट रेजोल्यूशन प्रोसेस में चले जाए। एंड वी सी के और ये आई थिंक पिछले आपको उसमें सेशन में ये बताया गया होगा कि जो इंटरनेशनल मीडिएशन इंस्टीट्यूट्स हैं वो उनका ख्याल है कि उनके पास जितने केसेस आते हैं मीडिएशन के लिए उसमें से अराउंड 80% शायद वो रिजॉल्व हो जाते हैं थ्रू मीडिएशन। But I would say that even without going to a formal mediation structure, in my day-to-day practice, I frequently see, in fact, encourage clients to opt for a mediation solution. और उसमें अगर दोनों parties ने lawyers engage किए हैं तो one can go to a big four consultancy firm and say कि जी इनका managing partner जो है उस country का can be the mediator and can help discuss things. एंड फ्रैंकली जो कम से कम पाकिस्तान और मिडल ईस्ट के कॉन्टेक्स्ट में मीडिएटेड सेटलमेंट्स जो मैंने देखी हैं उसमें इतना कोई स्ट्रक्चर्ड मीडिएशन प्रोसेस फॉलो होते नज़र नहीं आया, राइट। सो ये बिल्कुल इट प्रोवाइड्स सर्टेनिटी, इट प्रोवाइड्स अ स्ट्रक्चर कि जिस तरह आपको बताया गया है उस तरह मीडिएशन को फॉलो किया जाए, दोनों पार्टी स्टेटमेंट्स करें, फिर अगर जॉइंट होने की ज़रूरत है डिस्कशन वो हो, और फिर फाइनली सेटलमेंट की तरफ चीज़ जाए। बट यू शुड कीप इट इन माइंड कि इन रियलिटी एंड इन प्रैक्टिस खास तौर पे बड़े डिस्प्यूट्स पे इट्स नॉट रियलिस्टिक टू एक्सपेक्ट कि अगर आप 1 दिन की या 2 दिन के ऊपर मीडिएशन हियरिंग्स रखेंगे एंड यू विल वॉक अवे विद अ सेटलमेंट। एक तो ईगोज और इमोशंस बहुत इन्वॉल्व होते हैं, फिर जहां आप पैसे की बात कर रहे हैं तो nobody comes to a mediation meeting expecting to give up large sums of money or their rights in just one go. So in my recent experience, ठीक है मैं कुछ जरा ज़्यादा बड़े commercial matters की बात कर रहा हूँ, but the mediations have lasted weeks if not months. And you know they have been back and forth, you know दरमियान में टाइम मिलता रहा है, बिल्कुल रिटन सबमिशंस बिल्कुल होती हैं और कुछ हद तक वो एक स्ट्रक्चर फॉलो होता है, बट अदर देन दैट इट रियली इज लाइक एनीथिंग एल्स। आप लिटिगेशन का भी अगर आप बिल्कुल आप टेक्स्ट बुक वाले तरीके से चलें तो फिर तो हर चीज़ हमारे CPC CRPC में प्रोसेसेस दिए हुए हैं कि किस तरह केस फाइल होना चाहिए, किस तरह हेयरिंग्स होनी चाहिए, कितने टाइम में सब कुछ कैसे चलना चाहिए। इन रियलिटी ऐसा होता नहीं है, as we all know. So I would say mediation is
I'm sorry, you know this is fabulous. This is one angle that we were missing from our previous discussions, and you know I also come from a commercial background, so I can totally relate to the scenarios, dispute resolution के clauses का contract के अंदर और ये सारी चीज। कोई एक ऐसा and we would like to benefit from your experience. कोई ऐसा case आप अगर share कर सकें in this time frame, जो of course you're saying duration भी लंबी है या सब कुछ है, but and you're saying most of them get resolved, which really stumped you and then it did go towards resolution because of this.
हाँ, अब मैं एक सिनेरियो का मैं जिक्र करता हूँ अगेन ऑब्वियसली विदाउट टेकिंग द पार्टीज नेम्स. उस सिनेरियो में एक मिडिल ईस्टर्न पार्टी थी और एक वेस्टर्न पार्टी, एंड दे बोथ हैड अ जॉइंट वेंचर and it was not working for various reasons. The joint venture related to different plants and factories in the Middle East region. I was asked, I sort of knew both parties, and I was asked to step aside as a counsel to the company or things like that, and just in fact help mediate the shareholders dispute between the parties. Right. जब वो डिस्प्यूट शुरू हुआ और जब मीडिएशन शुरू हुई प्रोसेस, तो उसमें ये ख्याल था कि जी जो यूरोपियन पार्टी है वो मिडिल ईस्टर्न पार्टी को बाय आउट कर लेगी एंड टेक कंट्रोल ऑफ इट्स एसेट्स एंड ऑपरेशंस इन द रीजन. और जो मिडिल ईस्टर्न पार्टी थी वो भी इसी माइंडसेट के साथ मीडिएशन में आई कि हाँ ये ठीक है, यू नो हमें अच्छे पैसे मिल जाएं, हमें सही चीज़ हो जाए तो वी विल गो आउट, क्योंकि अदरवाइज तो ये आर्बिट्रेशन चलती रहेंगी कई साल, एंड आर्बिट्रेशन इज नो डिफरेंट एज वेल फ्रॉम मीडिएशन. वो 6 महीने में कोई आर्बिट्रेशन खत्म नहीं होती. आप किसी किताब में आप ये पढ़ रहे हैं तो भूल जाएं, राइट? सो ये अपने LLM के कोर्स में या कहीं, सो मीडिएशन की भी इस तरह ये चीज़ शुरू हुई. और मैंने विद ऑल बेस्ट इंटेंशंस उनकी दोनों के पॉइंट, जिस तरह आपने पहले बात की कॉन्फिडेंशियलिटी, आप एक पार्टी की बात दूसरी पार्टी को नहीं बता सकते, बट यू एट द सेम टाइम हैव टू फाइंड कॉमन ग्राउंड्स जिन पे मजीद डिस्कशन हो सकती है in terms of resolving an issue. So and it's a big company, few $100 million की मैं पोर्टफोलियो की बात कर रहा हूँ इस रीजन में. At the end of the day, through various mediation rounds, और वो mediation rounds जो हैं वो हमारे ये डिसाइड किया गया था कि जी लेट्स से वो कंपनी फॉरेन पार्टी जर्मनी में थी और मिडिल ईस्टर्न पार्टी की बेस दुबई थी, कि दुबई और जर्मनी में मीटिंग नहीं होंगी कि किसी एक पार्टी का इन्फ्लुएंस ना हो लैंग्वेज या कल्चरल या व्हाटएवर. मीडिएशन मीटिंग जो हैं वो मुख्तलिफ और जगहों पे. सो वो ये भी एक रियलिटी देख लें कि ये नहीं होता कि आप बैठे हैं एक मीटिंग रूम में और उसी वक्त मीडिएशन हो गई. फॉर दैट मीडिएशन प्रोसेस आई हैड टू ट्रेवल टू लेट्स से लंदन एंड जिनेवा एंड अदर प्लेसेस and Istanbul in order to finally there are 3 sets of international meetings which took place before the matter was resolved. And the funny thing is, and the interesting thing is, कि जब वो मामला खत्म हुआ तो it ended up being resolved in a completely different manner from where the party set out you know to start the mediation process. और मिडिल ईस्टर्न पार्टी ने एट द एंड ऑफ द डे वो सारी शेयर होल्डिंग ले ली यूरोपियन पार्टी से, राइट? इट वाज कंप्लीटली ऑपोजिट. मतलब एक होता है ना कि आप मीडिएट कर रहे हैं तो प्राइस ऊपर नीचे हो जाएगी या राइट्स आप नेगोशिएट कर लेंगे या रिजर्व मैटर्स क्या होंगे जॉइंट वेंचर के अंदर, माइनॉरिटी शेयर होल्डर की क्या प्रोटेक्शन होंगे एंड ऑल. नहीं, वो जो पार्टी लेने आई थी उसने कहा कि नहीं, ऑन द बेसिस ऑफ एवरीथिंग एल्स we'll sell all of it.
So this is awesome because this is exactly वो जो unknowns की हम बात कर रहे थे, वो वही सिनेरियो है कि you never even started seeking that outcome, but that's the outcome that presented itself.
Absolutely. और फिर मैं ये कहूँगा कि जी देखें, in reality in commercial matters इस तरह के matters के अंदर mediation का ये मतलब नहीं है कि आपने mediation हो गई, दोनों पार्टीज ने एक एग्रीमेंट साइन किया और बस आपका काम खत्म हो गया कल, राइट? इस तरह की चीज के अंदर मीडिएशन का तो जो उसके बाद एक सेपरेशन प्रोसेस है वो भी 1-2 साल पे मुहित है, जिसमें फिर दोनों पार्टीज के लॉयर्स वो एक्शन प्लान इम्प्लीमेंट करेंगे कि जो मीडिएटेड सेटलमेंट है उसमें जो चीजें एग्री हुई हैं उनको एग्जीक्यूट भी तो करना है फिर टू सी इट थ्रू. बिकॉज अगर उसमें कहीं इंटरप्रिटेशन में इशू आ गया, कोई और चीज आ गई, देन यू आर बैक ऑन द मीडिएशन टेबल, राइट, ऑन दैट स्पेसिफिक पॉइंट. चाहे ओवरऑल एक कॉन्सेप्ट आपका एग्री हो चुका है. So that's the other thing I would say कि जी the main mediation, the settlement is not the end of the mediation process as well. You know, you will see invariably in real life कि जी कोई ना कोई थोड़ी सी और mediation की ज़रूरत you know in the months to come, year to come उस issue से related रहेगी. Again ये कहीं textbook में या आपको rules में नहीं मिलेगा.
Exactly.
But that's the reality.
So if I may, we say it's not the be all end all that we trying to propagate here. We have to take it with a pinch of salt, and the outcomes, of course, if it leads to a better outcome in expanding the pie, that's the real deal there with any of our dispute resolution mechanisms, especially that are non-adversarial. So वो उसमें जो है ये we really appreciate this insight, or not just one insight. I think this was full of nuggets and while you were saying, I was reminded of a book that I came across and we used for this. It's called Nudge, and the role of that nudge or as a nudger, that's a key element for a mediator. So you have to nudge people in certain directions where you see opportunities, and then you try to capitalize on those opportunities. Thank you very much, Taimur. So it's really it is, and we are flattered that you chose to join this forum. It is really an honor to have you.
Thank you very much. Always a pleasure, and I wish you all success with this program. And thank you for inviting me.
Thank you very much.
Thank you so much, Barrister Taimur. The purpose behind inviting you, I think, has been fulfilled because you wrapped it up so beautifully. And Amitabh is right that this was the aspect we've not been touching, because commercial aspect की जब भी बात आती है हम सिर्फ arbitration को ही consider करते हैं और हमें लगता है कि mediation शायद वहाँ पे possible होती भी है तो it's too tough. अगर आप बड़ी companies की या बहुत अच्छे बड़े joint ventures की बात कर रहे हैं, but the example you have quoted, it is actually is really interesting कि mediation आपको बहुत सारे ऐसे ways and paths, it shows you which you normally do not think about when you were starting this. So thank you so much, Barrister Taimur. I think कि time की वजह से हम और बात नहीं कर सकते, otherwise talking to you and listening to you is always a pleasure and always so inspiring. Thank you so much for joining us. Thank you. Our next worthy speaker, he has just joined us, Barrister Saeed Nagra Saab. Sir, we are so honored that you have taken time out to speak to us. Barrister Saeed Nagra is an experienced and learned lawyer. He is Vice President of Lahore High Court Bar Association and one of the staunch supporter of mediation. Sir, आपसे हम कुछ जानना चाहेंगे mediation के बारे में. आप as a आप इतनी you're a Vice President of Lahore High Court Bar Association, तो आप इसके बारे में क्या सोचते हैं? हमारी courts या हमारे judicial system में ये कैसे एक parallel part बन के काम कर सकता है? Over to you, sir.
देखिए, फर्स्टली तो मैं ये समझता हूँ कि दिस इज़ द नीड ऑफ द आवर, और इसका जो मेन जो ऑब्जेक्टिव है इसका वही है कि रिड्यूस द बर्डन ऑन द जुडिशियल सिस्टम, एंड दैट मस्ट बी एनकरेज्ड इन एनी फॉर्म, क्योंकि अल्टरनेटिव डिस्प्यूट रेजोल्यूशन की ये जो है एक वन ऑफ द फॉर्म इज मीडिएशन. मैं आपको अपना एक एक्सपीरियंस शेयर करूंगा कि आई डू प्रैक्टिस इन इंग्लैंड एज वेल. आई गॉट माय फर्म देयर. सो अब इंग्लैंड में इन चीज़ों को स्ट्रिक्टली जो है वो एडहेयर किया जाता है कि बिफोर इनिशिएटिंग द प्रोसीडिंग इन द कोर्ट, the parties, they are considered to have mediation or any other sort of alternate dispute resolutions. They are encouraged to sit with their lawyers, and their lawyers are bound to advise them to put their cards on the table, so that if the matter is still taken to the court after the whole procedure is done, the court would be in a position to assess this, that whose behavior is reasonable and who was unreasonable in sorting the matter outside the court. अब उसमें चीज़ यही आती है, हमारे पाकिस्तान में भी ये चीज़ें जो हैं आजकल जो है ये काफ़ी ज़्यादा जो है मैं समझता हूँ कि इनकरेजिंग हैं कि लोग जो हैं वो उनका ट्रेंड जो है वो मीडिएशन की तरफ जो है वो जा रहा है, क्योंकि और इसमें मैं एक चीज़ ये समझता हूँ थोड़ी सी, मैं अगर कंपेयर करना शुरू करूँ दोनों सिस्टम्स को, कि ये हमारा लॉयर्स का जो है ये बहुत एक इम्पोर्टेंट रोल है इस चीज़ में, कि हम लोगों को भी अपने क्लाइंट्स को जो है वो इनकरेज करना है कि यार लिटिगेशन के अलावा भी तरीके हैं अपने मामलात को सॉर्ट आउट करने के लिए, लेकिन उसके लिए दोनों क्लाइंट्स का जो है वो भी विलिंग होना इसके लिए जो है बहुत ज़रूरी है। ठीक है, हमारे जो है कोई 2 साल पहले जो है एडीआर का जो है सिस्टम जो है यहाँ पे इंट्रोड्यूस होना शुरू हुआ, उसमें जो है एक्टिवली इस चीज़ को डिस्कस भी किया गया, और जुडिशल जो है वो हमारे जो जुडिशल सिस्टम में भी हमारे जज साहबान जो हैं उनको भी ट्रेनिंग दी गई कि जी जो है जो मैटर्स जो हैं उनको सॉर्ट आउट जो है वो अल्टरनेट वेज में कर लिया जाए इंस्टेड ऑफ ब्रिंगिंग द मैटर्स इनटू कोर्ट। तो उसके लिए जो है वो इन्होंने हर जो डिस्ट्रिक्ट में जो है वो जो जजेस जो हैं उनको भी अपॉइंट किया। मेरा थोड़ा सा इसमें एक पॉइंट ऑफ व्यू थोड़ा सा डिफरेंट है, क्योंकि इसके लिए इन्हें ये चीज़ चाहिए कि दे शुड हैव एनकरेज द लॉयर्स, बिकॉज मीडिएशन में अगर आप जुडिशरी को ही इसमें इंक्लूड कर लेंगे तो फिर उसमें वो एक यही सिस्टम हो गया कि जी मैटर आप लोगों ने इनिशिएट किया है कोर्ट में और वो उसके लिहाज से चल रहा है। लॉयर्स को इनकरेज करना चाहिए कि वो जो है इस प्रोसेस में आए, इस प्रोसेस का हिस्सा बने, कोई सुपरवाइजरी बॉडी जो है वो उसके ऊपर एक बननी चाहिए, वो इनको इनकरेज करे, पार्टीज बैठे अपने मैटर को सॉर्ट आउट करें, लेकिन उसमें कुछ इसका एक मैकेनिज्म एक होना चाहिए। मैकेनिज्म जो है वो इसमें यही बनता है कि पार्टीज को ये पता होना चाहिए कि उनका जो बिहेवियर है एट द एंड ऑफ द डे दैट वुड बी काउंटेड एज वेल, और ये बिहेवियर जो है वो उसको एंड पे जो है वो कॉस्ट कॉन्सिक्वेंसेस जो हैं, whoever was unreasonable he has to face the cost consequences as well। कि मैटर को अगर कोर्ट में जाता है, अगर पहले पार्टीज फर्ज करें अगर मैं एक पार्टी हूँ, मेरे हक में मीडिएशन में फैसला जो है वो नहीं आया, तो मैं अगर कोर्ट में जो है वो चला जाता हूँ, तो इफ द मैटर इज डिसाइडेड इररिस्पेक्टिव ऑफ द फैक्ट कि मैटर मेरे फेवर में डिसाइड हो रहा है या मेरे अगेंस्ट डिसाइड हो रहा है, बट मेरा एक जो बिहेवियर है दैट वुड बी काउंटेड, वो चाहे रीजनेबल है अनरीजनेबल है। तो एट द टाइम ऑफ अवॉर्डिंग द कॉस्ट जो है कोर्ट जो है वो ये लाजमी डिटरमिन करेगी कि मैंने जो है कितना मैंने अपनी तरफ से कोशिश की कि मैटर जो है वो आउटसाइड कोर्ट जो है वो सेटल हो जाए। तो जितनी हमारी इधर लिटिगेशन की तादाद यहाँ हो चुकी है और एक एक कोर्ट में जो है वो सैकड़ों केस लगे होते हैं, मैं ये समझता हूँ कि दिस इज द नीड ऑफ द आवर, कि मीडिएशन जो है वो बहुत ज़्यादा ज़रूरी है आजकल के जो हालात जा रहे हैं हमारे उसके लिहाज से। और इसमें दूसरी बात ये भी आ जाती है कि इसमें थोड़ा सा कंडक्ट इश्यूज भी आ जाते हैं, तो ये भी चीज़ देखनी चाहिए कि लॉयर्स जो इस चीज़ को देख रहे हैं या जो भी इन्वॉल्व है इसमें, वो इसको एथिकली भी उसकी जिम्मेदारी जो है वो कितनी लेता है इस सारे प्रोसेस की। तो इसका फायदा जो है वो उसी सेंस में होगा जब पार्टीज को बाउंड किया जाए कि whatever रिजल्ट जो है वो कम्स अप दैट वुड बी कंसीडर्ड बाय द पार्टीज, और ये ना हो कि जस्ट मीडिएशन प्रोसेस को जस्ट आप इसको बढ़ा रहे हैं जस्ट टाइम ज़ाया करने के लिए, कि अगर एक पार्टी टाइम लेना चाह रही है कि उसको कोर्ट में ना ले जाया जाए तो वो मीडिएशन में आ जाए, वहाँ टाइम वेस्ट करने के बाद जो है बाद में दोबारा इफ द पार्टी इज नॉट एग्रीइंग टू इट तो वो कहे जी ठीक है मैंने इतना टाइम तो ज़ाया कर लिया, अब ठीक है मैं कोर्ट में भी चला जाता हूँ और वहाँ जाके भी इस चीज़ को देख लेते हैं। तो ये जजेस की भी जिम्मेदारी है जी।
So thank you very much. You know, this is really insightful. I think जो एक and you practice in the UK as well. So the challenge of the mediation or any alternate dispute resolution programs moving toward professionalization, right? So जो वहाँ पे तो एक profession के तौर पे establish हो चुका है. This is really in infancy here. So and we've seen it primarily pushed through court annexed mediation. And then hopefully the recent legislation आई है that there is an effort to slowly push it towards that direction. And the code of conduct thing, I think that is an important element जिस पे काम हो भी रहा है, लेकिन इस लेवल पे नहीं हो रहा कि हम इसको इस वक्त या इतना मोमेंटम अभी नहीं है कि उसको किसी तरह से जो है प्रोफेशन के लिए लाजमी करार दिया जाए. But that's a very important point that you highlighted here, sir. You know,
मैं आपको थोड़ा सा इसमें ऐड करूंगा कि हम लोग इसमें जो है अब यूके में फर्ज करें कि इफ सम क्लाइंट इज कमिंग टू मी मुझे सबसे पहले मेरा कंडक्ट इशू ये है, मैं बीएसपी की तरफ से, बार स्टैंडर्ड बोर्ड की तरफ से या लॉ सोसाइटी एसआरए की तरफ से मैं आई एम बाउंड कि मैं उस बंदे को ये बताऊं कि यार फर्स्टली यू हैव टू सीक दैट अपॉर्चुनिटी, वी नीड टू टॉक टू द अदर पार्टी, वी नीड टू राइट अ लेटर टू हिम एंड वी नीड टू टेल हिम दैट वी नीड टू सिट बिफोर स्टेपिंग इनटू द कोर्ट। और वो जाहिर है दूसरी पार्टी भी अपना सोलिसिटर या बैरिस्टर जो है वो उसमें इंस्ट्रक्ट करती है, तो फिर ये बैठ के कोशिश ये होती है कि हम ये मैटर को आउटसाइड कोर्ट सेटल करें। अगर नहीं किया जाता, अगर कोर्ट में भी जाता है तो कोर्ट भी प्रोसीडिंग जो ही नोटिस करती है कि इस मैटर में ये दोनों पार्टीज बैठ के इन्होंने अभी आपस में कोई अल्टरनेटिव वे नहीं ढूंढा, कोर्ट भी प्रोसीडिंग्स को वहीं स्टे कर देती है, स्टॉप करती है और उन्हें टाइम देती है कि जस्ट गो बैक एंड जस्ट गेट द मैटर सॉर्टेड, एंड इफ द मैटर सॉर्टेड दैट्स फाइन, इफ नॉट देन कम बैक टू अस। बट कोर्ट उसमें फिर ये करती है कि कोर्ट एट द टाइम ऑफ अवॉर्डिंग द जजमेंट, court does consider the reasonability of the parties, how they behaved during whole that process, and while awarding the cost, the court definitely consider this element as well, who was reasonable, who was unreasonable. We got many cases in which though we were right, but our clients, they were not even willing to accept the offer which was given at the time of mediation, at the time of when they were sitting with us and the other party. We did advise, because at the end of the day, it's up to the client whether he's going to accept it or not. So most of the time, the clients were as unreasonable. But when we took the matter to the court, and after the proceedings done, court realized that their behavior was unreasonable. Doesn't matter they won the case, but the court did not award them the reasonable cost, because they deducted the amount from their award, because their behavior was unreasonable at the time of the alternative dispute.
I agree. So Joyce, that is why perhaps we have this effort where we need to bring in public-private partnership to work on initiatives where we can actually, one, create awareness. Second, of course, nudge it towards that particular scenario where we can actually encourage people to, or professions to have that code of conduct where everyone is held to a higher standard. Because, of course, our environmental concerns or our social scenarios also come into play, and if you are in an established or a developed country legal system, you know what people can get away with here, we don't have those things in established legal jurisdictions. So that's something we really need to be mindful of, and that is why I think the effort that is being put, and that is why we need outside support also to kind of encourage people or to support the system to go in that direction. I really appreciate your input, Said Saab. What would be your parting thoughts on this?
I invite you guys that you should plan a program and do this at the high court level. And I think it would be really good to encourage our community, so that they will be in a position to encourage their clients, whoever comes to them, and at least they will be in a position to advise them, okay, instead of going into court, let us sit on the table, put our cards on the table, and if the matter is decided outside the court, that would be less what I would say, okay, they would no effort involved in it, so they would avoid
that's
We're
just
losing your sound.
Yeah, we are unable to hear you.
Sorry, that's what I told, that the initiative taken by you is really appreciable, and I think such like event should be held in a high court level as well. And I welcome you guys to come here and organize such kind of seminars, and it would be really fruitful for our community as well. At least we would be in a position to encourage our lawyers to advise their clients before filing the matters to the court, and this would be really fruitful at the end of the day, what I believe.
Really appreciate that, Joy Sab. I think that's one of the next logical steps that we have. And we are honored by your presence today. Thank you very much for sparing your time for us. Thank you, sir. And we really look forward to connecting with you as a follow-up to the offer that you made. It's a very generous offer, and we would really like to take you up on that shortly. Thank you. Aisha, back to you.
Thank you so much, Barrister Saab. It's an honor to have you with us, and definitely, I think talk with you has led us into another direction that we should be more strategized, and we should lead it, at the higher level as well. So, inshallah, we'll be contacting you, and we'll be doing it very, very soon. As we are moving towards the end of, thank you, sir. As we are moving towards the end of the webinar, so I would request Ahmed Saab if you have, few words to say, and then we'll just wrap up.
So I have a couple of visuals that I want to share in the tradition of what I've done so far. Everybody recognizes Amal Clooney, right? So that's George Clooney's wife, but in her own right, she's one of the best legal minds out there who works on a lot of human rights and social justice issues. So I did put together a sort of a list, like what does a mediator need to have? Of course, you need to have your feet firmly planted on the ground. You need to keep your ego in check. You need to have a high level of emotional intelligence. You need to have cultural agility. You need to have a reputation for fairness and accuracy. I'm just echoing something that Sherzad also came up with. Diplomacy. Tact is an important element there. You can't bulldoze your way. You really need to be respectful in those situations. And keeping your eyes open, your ears open, have those active learning communication skills to support yourself. Finally, this is what I really wanted to part with. We have so far, or I have shared 6 books last time. There were 3, but while Temur was talking about certain things, I was reminded of this book that I had used. One of my favorite books is, of course, Stephen Covey's 7 Habits of Highly Effective People, really useful for personal development. But at the same time, the other book is Deepak Malhotra and Max Bezeman, very, very impressive Harvard Business School professors. And I met them in my program when I was there. And this was, these are some of the most fascinating commercial negotiation dispute, and also they have insights that apply to any negotiation scenario, because that was also one of the themes I used today. Nudge, amazing about how you can be in those scenarios. Again, facilitation skills is the overarching theme in this one, how you can facilitate any scenario. I also wanted to sort of parting words, thank everyone for being here, being patient, listening to us, and asking some of those questions that have really enriched us in terms of our own learning as well. It is sometimes frustrating, like, yes, we talk about things, but how do we see those in practice? But this is just a step in that direction, and I wish all of you well, and really want to appreciate the dedication, motivation that you guys give me by showing up and being here with us. Thank you. Aisha, back to you.
Thank you so much. I'm wrapping it up. Thank you so much to the Asia Foundation for providing us this platform. And I'm really indebted to our worthy speakers throughout this series who have taken their time out and give us inspiration and motivation, and give us some really deep insights into this field, and make things clear to our young lawyers and to our students. And I'm really thankful to our audience who's been here and who's been motivating us through their questions, through their inputs. And also there's one person I would really like to thank is Ms. Myra Bukhari, who has been coordinating these sessions with me, and Nadira Hassan Law Department faculty, and of course Kinnaird College, who has always been very, very supportive for these things. And if it's not the support of the administration, this department would not have been doing what we are doing. So I'm really thankful to everyone. And hopefully what we have decided, what the commitments we have made in these series will be coming forward, and we'll be having some concrete leading steps in future, inshallah.
Excuse me, ma'am. Excuse me?
Somebody, I can't hear. Somebody wants to say something.
Yes, ma'am. Actually, I have a question. I would like to any of the guests to answer, please.
Please write your questions in the chat box. We'll be taking it afterwards. I'm really sorry. Time is up, so we are just winding up. So please chat box mein likhiye. We'll get back to you. Please, give us your number or email address. We'll be contacting you soon. Thank you so much. Allah Hafiz.